On Monday, the 5 men accused of planning the 9/11 attacks will sit in a high-security courtroom, and prosecutors and defense lawyers will debate what should happen during their upcoming trial, a trial that probably won't start before 2019 at the very earliest.
These cases should have been prosecuted in federal court. Had they been prosecuted in federal court, they would have been over and done with by now.
Some of the issues on the docket include the defense wants evidence of what it calls suspected government spying on conversations between the lawyers and detainees. It also wants access to International Red Cross records about the accused. And defense lawyers have filed several motions to dismiss the case because of various alleged government violations and conflicts of interest. These pretrial hearings have been taking place since May 2012, calling into question whether the government is doing enough to make sure the defendants get a speedy trial. Human Rights Watch argues that the treatment of the detainees during the so-called global war on terror is also to blame for the delays.
A lot of the problems with the military commissions in Guantanamo stem from the fact that the U.S. government has been trying to hide the torture that the U.S. used on detainees who are being prosecuted in the commissions.
Analysts say there is another cost.
It's a bad situation, and one of the reasons it's a bad situation, obviously, for the families of the people killed on September 11th, they want to see justice. And this is going on so long, it becomes an issue of, will they be healthy enough to testify? Will they remember?
But legal experts say that because this is a death penalty case, defense lawyers are obligated to raise every possible objection.
But what they're really looking for is, at the margins, making sure that they have all the evidence that they think they need to offer what they're going to put on as their defense, and making sure that there's a record created of those issues on which the trial judge denied their motion, so that if they really think it prejudices what happens at trial, they can then raise that argument afterwards on appeal.
The military judge is expected to issue his rulings after the week's hearing is over. What he won't be doing is setting a date for the start of the trial. There's still much prep work to be done. Rosalind Jordan, Al Jazeera.